everyone, my name is Gaston and I'm here with today's Markman Minute, where we take a look at interesting events in the world of patent litigation that have an impact on investors and the markets. And for today's Markman Minute, I wanted to talk to you about an interesting situation with a company called RPX. And before we get into what RPX has recently done, I think it makes sense to get a little bit of an understanding of how RPX originated and what it does generally. So RPX is a publicly traded company that is in the business of trying to shield its members from patent troll lawsuits. And it goes about protecting its members in a number of different ways. Originally, RPX's model was a very simple one. It would look for patents that could be asserted against multiple members and would do deals and acquire them and basically take them off the market, kind of proactively keeping them out of the hands of patent trolls. RPX has also gotten involved in a number of other deals over the years, but they really all stem from the model of going to large technology companies that are likely to be sued by patent trolls and offering them a subscription-based service whereby RPX is acting on their behalf and proactively trying to protect them from patent lawsuits. Now, one of the things we've talked a lot about over the past few months has been the rise of what we call the rise of the IPR, or the inter-partes review, in the patent office. And it has been our opinion throughout that this IPR process has really changed the strategic landscape for patent players of all sizes. And that includes patent assertion entities and patent defendants. And it's no surprise to us that RPX has started to incorporate what seems to be an IPR-based strategy into its menu of offerings on behalf of its members. So let's focus on what RPX has done historically with our IPRs and what they recently did and see kind of how that has evolved. So the first instance where we saw RPX involved in IPRs involved a publicly traded patent assertion entity called Vernetics. And Vernetics had a number of patents that they asserted against Apple, which is a large RPX client, and had been very successful in getting a large jury verdict in the Eastern District of Texas against Apple. Now, that case was going on before IPRs really were available to Apple, which created what we've talked about in the past, which is the time bar problem for patent defendants. And the time bar problem is basically if you've been sued with more than a year has gone by since you were first sued by the patent owner, then you cannot bring an IPR. And because of the way the IPR system rolled out, there's a subset of cases that were filed prior to the IPR legislation where the defendants in those cases never had an opportunity to IPR at all. And Marvell in the Carnegie Mellon situation is an example of something we've talked about as well. So Apple was not able to IPR Vernetics' patents. RPX jumped in at some point and actually filed IPRs on Apple's behalf on the argument that these patents are invalid, and even if we can't save Apple from having to fight Vernetics in court, we could at least limit the damages and maybe reduce the need to pay ongoing royalties if we invalidate the patents. Now, those IPRs were not instituted by the Patent Office because of the argument that RPX was really just acting as Apple's proxy, and it was an improper end around the IPR process to allow RPX to step into Apple's shoes and avert the time bar problem. So that's the first example we have of RPX jumping into the IPR waters. The next time we see RPX jump in is in a situation where an investor, or a short-selling investor by the name of Dr. Mike Farnwald, who's associated with Rambus, a patent assertion entity in its own right, filed IPRs against Parker Vision, again, another company that we've talked about in the past. RPX partnered with Farnwald to file IPRs against Parker Vision's patents. And those IPRs have since been stayed. So RPX until now has shown an indication to look for opportunities to jump in and file IPRs on behalf of its members. In the case of the Apple, it was obviously on behalf of Apple. In the case of Farnwald, it was on behalf of Qualcomm, which was the defendant in the Parker Vision lawsuit. What's happened recently? There's an interesting case that's going on between a patent assertion entity called Applications and Internet Time where they filed a case a few years ago against Salesforce. Now, Salesforce is obviously a very successful large company. Salesforce's problem is they cannot IPR the patents because of the time bar issue. And what we've seen is RPX has now come in and filed IPRs against Salesforce's patents. What this means for investors in both RPX and Salesforce and any other member of RPX is that RPX seems to be taking a more assertive and aggressive approach in protecting its memberships, not only by looking for patents to buy, but actually looking to challenge patent assertion entities that have the gall to file lawsuits against RPX's patents. That's it for this week's Markman Minute. Thank you for listening. You could check out all our content on mimesaslaw.com under the Intellectual Property tab. I'm Gaston from Markman Advisors. Thanks for listening.
Under the central patents to you, and we want a few dollars for every Xbox that you sell. However, the